Hello, my name is Melissa Worth and I am a solicitor specialising in dispute resolution, which means that I help businesses and individuals to resolve their commercial disputes. Each week I am reviewing a recent case, and this week I have chosen the case of Fine Care Homes Ltd and National Westminster Bank plc, which was handed down on the 27th of November 2020. This is another case which deals with allegations of negligence, but this time the allegations relate to the bank's sale of an interest rate swap product. The claimant, a care home, alleged that the NatWest, the defendant, had missold a complex interest rate hedging product known as a structured collar. This is an interest rate swap product. The claimant's director argued that he had relied upon advice given to him by various employees of the defendant. Now, these particular products were already under the spotlight, and the bank had undertaken a review of this transaction by order of the Financial Conduct Authority. Following the review, the bank offered the claimant a partial refund of £384,258.50. By the time of the review, the claimant had already issued proceedings at court, and so the proceedings were stayed to allow the review to take place. The claimant did not accept the defendant's assessment following the FCA-ordered review, rejected the offer, and pursued a negligence case and mis-selling case to court. To explain a little bit more about the background, the claimant's relationship with the defendant started in 2005 when the claimant needed significant funds to develop a site in Harlow. The collar was entered into in July 2017, and the value of the collar was £4 million, and its initial term was for 5 years. Unfortunately, this was terrible timing and was just before the global financial crisis following the collapse of the Lehman Brothers in 2008. The resulting dramatic plummet of the interest rates impacted the payment which the claimant was required to pay to the bank. The interest provisions of the collar were complex, and so I will not go into them in detail now. But the effect of the interest rate provisions in the agreement meant that the claimant had to pay £240,000 per annum initially to the defendant, and this figure increased very significantly in the subsequent years. It's fair to say that the claimant did not have an easy ride to trial, and during the proceedings, the claimant had to respond to the defendant's application to strike out various elements of the claimant's case. By the time the case reached trial, the claimant's case was as follows. The court was asked to consider whether the bank had a duty of care and therefore negligently advised the claimant about the suitability of the collar. The court was also asked to look at whether the bank provided information that contained misstatements or misrepresentations about the collar. The court was asked to consider whether the bank had failed to exercise reasonable skill and care when giving advice and representations pursuant to Section 13 of the Sale of Goods and Services Act. The court was also asked to consider whether there was an express or implied term that the bank must comply with the principles contained within the FCA handbook. At trial, the judge categorised these allegations into two. The first categorisation was whether the dealings between the parties gave rise to an assumption of responsibility and duty of care in respect of any advice. The second set was whether there was an advisory duty and whether that duty, if it existed, had been breached. The judge found that, on the facts, the bank had not advised the claimant to buy a particular product. Therefore, the bank did not need to go on to consider the specific duties which the claimant had argued the bank had breached. The judge also held that the bank had not negligently failed to spell out that by exceeding its credit limit meant that the claimant's ability to borrow more money would be reduced. The judge also dismissed the claimant's allegations of misstatement and misrepresentations. The judge stated that, while I fully acknowledge the genuine nature of the claimant's sense of grievance, I found on the facts that the bank did not breach its duties in the way the claimant alleges. The claimant's entire case was dismissed, and this must be a devastating outcome for the claimant in circumstances where it had rejected the bank's partial refund of close to £400,000. Factual evidence featured very highly in the trial, and the judge gave short shrift to the claimant's factual accounts, at one stage stating, quite apart from the improbability of such precise recall of conversations with the bank, the claimant's account was confused and inconsistent. I do not therefore consider the claimant to have been a reliable witness. Once again, this is a case that demonstrates that pursuing a case to trial, which relies very heavily on witness evidence, is a high-risk strategy. In any case, a careful review of the witness evidence after exchange is crucial to ensure that the risk of proceeding to trial is still merited, or whether a negotiated settlement ought to be attempted. If you have any queries or comments about this case, please do get in touch. Many thanks.